This is a broad topic and a very important subject. And there are changes that are going to come here. There are changes that are going to come soon to this state, even if we don't immediately start becoming more active in terms of the actual development and operation of the university. And there are two very important things going on politically, and you guys have already learned about that this morning, but I'm going to emphasize them because you have an opportunity to affect this state. As an attorney practicing in this area of the law, I am not the designer of the process. I'm not the architect, I'm not the engineer of the process. The engineer and the designer of the process is the legislature and the governor. They make the rules, most of the rules. Occasionally those rules are interpreted by courts and are subject to the foibilities of human judgment. But most of the rules that affect much of what we're talking about are statutory. So I'm reporting to you as a plumber, as an electrician, not as an engineer. I'm the plumber that deals with what I'm given, the reality of where the plumbing pipes are. That's what a lawyer does. He practices with what he's got. In this state, we have the ability to affect some of this because all of the legislation that should be in place isn't necessarily in place. And some of the old legislation we have in South Dakota is old and needs looking at again. The governor, as has been indicated, has two committees that are studying infrastructure issues and potential issues of that nature. Very important. As citizens, as residents, give them your input. Please do. This is what the beauty of this state is access. One of my great friends is a fancy professor and was educated on the East Coast at Rutgers. His first job was at Northern State in Aberdeen, and he came up to me and we became friends. But he said to me, David, one of the most fascinating and wonderful things I'm experiencing here, because he's an East Coaster, born in New York City and educated in New Jersey and Rutgers. He says, access. You really do have access to the system, the political system, the process. It works. You can have access and you can affect it. It's extraordinary. It's impossible to get this kind of access in the East. He's right. So if you guys have opinions or goals or issues you want, use the access that you have. It's a wonderful thing in South Dakota that's still here. Use it, please. The governor is fundamentally focusing on the planning stuff, the infrastructure issues. The legislature is looking at a lot of the committee that Ruben is talking about is looking at a lot of the laws. How should any of the laws be revised, changed, amended, updated? Some of them should be, some of them perhaps shouldn't. So participate, participate, participate. This stuff goes on forever. This is not short-term stuff. It's called an oil boom, but I say it's an oil boom, but the process is in perpetuity. The process may die down, but the process will still be with us. The process of exploration, drilling, withdrawing, exploiting, etc. That's there. One thing that surprises people that I tell people is that this stuff doesn't just last for 5 years. There are oil and gas leases that are over 100 years old in operation in the East Coast of this country. 100 years under a lease that was written in 1890s, 1900s. You figure, how important is that lease? Okay, I'm going to say a few things about a statute that we deal a lot with, but not enough. A statute that many states have, 23 states have some version of this statute, the Dormant Mineral Act, the Dormant Mineral Statute. Dormant means inactive, and it is a way of resuscitating that which may have theoretically been lost. The history that Ruben presented is pretty true. It's very interesting. We pretty much in South Dakota adopted the statute that North Dakota adopted. But North Dakota didn't create it out of the Dormant Mineral Statute itself. But before we even talk about the statute, I want to talk about some of the principles of mineral rights. Mineral rights are real estate rights. Real estate law is what you look at first, because mineral rights are created by real estate law and are considered real estate. They're not something special. They're not an intangible asset. They're not a personal property asset. They're real estate. And in South Dakota, as in most other states, if you own the land, if you have title to the land, you have title to the minerals. There are two aspects to your ownership, since, to put it simply, the mineral rights and the surface rights. Those stay with the owners and go on with the subsequent owners throughout history. The owner, we're talking about private property now. I'm not talking about leased property, tribal land. I'm not talking about federal land, BLM land. It's a different can of worms, as it were. But for purposes of my conversation this morning, I'm going to be talking about private property. The mineral rights stay with the land. They stay with the land unless they're severed. That's just a fancy word. It means separated, changed, transferred out. They stay with the landowner. So if you're fortunate enough to own the land and it's never been impeded historically by somebody transferring it out, some predecessor owner transferring it out, you still own those rights. Now, it isn't always that simple because, of course, if you're buying land from the state and people are from there are other issues. We've got to be careful. We have to actually go back and look at some of the original patents sometimes on some land. And patents is just a fancy legal term. It means the original deed. The patent is the instrument that the government grants the land from, because we theoretically believe that the government owned the land in the first place. That's a legal fiction. But, so the mineral rights stay with the landowner unless they've been severed out at some point in history. Okay, are they severed? Yes, you do see a lot of times that they're severed, and the owners in South Dakota don't particularly know that unless they have a keen interest in it. The further east in the state you go, the more ignorant are the owners of the land as to the nature of their ownership in the mineral rights, which is typical because the further east you go, the less mineral development there is and the less attention there is paid to that. I will say that's even changing. It's very interesting. There are some interested parties now attempting to negotiate, that is, obtain leases from landowners along the Missouri River and the parks over in that area. So it's happening. We are a mineral-rich, natural resources-rich state. And we have to focus on that more as we go forward. Okay, so those mineral rights stay with the land unless they're severed. And how are they severed? They can be severed in many ways. Sometimes the landowner or rancher, for example, does it in a will. If he does it in a will, and the will is properly probated, he could give certain kids the mineral rights, or grandkids, or nieces, or his ex-girlfriend the mineral rights, and he could give the land to his latest girlfriend or his latest wife, or maybe even his first wife. Actually, it shouldn't be so facetious because I wouldn't want him to distribute it that way. So you could do it through the process of estate planning, through a will. Mineral rights can be transferred through will. They could be transferred by contract. They could be transferred by mineral deeds. And you'll hear and see mineral deeds. And I've seen some of the quirkiest mineral deeds in South Dakota because we have a tendency to adopt other people's documents because we don't have that much development in the mineral rights area. So you'll see some deeds that are written from East Coast deeds. You see some Texas deeds. You see somebody doing their own deeds. But you actually can have a deed of mineral rights. Most of you in here at some point in your life will have seen a typical real estate deed. And a mineral rights deed is similar to that. You can deed out your surface lands to X, and you can deed your mineral rights to Y. And that's a severing. Okay. A lease out by the surface owner is conceptually a way of severing. There are a lot of different ways that it can be done. It can be done for different purposes, different motives. You've got to go back and look at the history of the title of the land that you're dealing with, which again is an interesting question because for example, title insurance companies in South Dakota do not insure mineral rights. So you can't rely on a title insurance company to give you an opinion. You're going to have to find a lawyer that works in the area and can give you an opinion on the mineral rights of your land. Knows how to research and obtain an opinion. These rights are historically dispersed for different reasons. We've had two different boomlets that weren't really booms. I think even in my lifetime, in the 50s, there was a whole lot of activity going around, at least in terms of leasing and some modest exploration, which died out. And then in the 80s, there was again some activity in terms of you see spurts of more leasing going on. It doesn't mean spurts of development, but there's been consistent modest development always, for example, in Harding County and then some in Fall River, to name two off the top of my head. When you go through these spurts and you look at the title history of property in South Dakota, you see that somebody thought that there was something going on. So you see a lot of mineral rights transfers that took place in the 1950s. less so that some that you see took place in the 1980s. The 1980s were affected by the mini boomlet of the 80s in North Dakota, which many of you know about, which is the pre-boomlet to what we're dealing with now. That wasn't really Bakken-based, it was something else based, and it wasn't fracking-based. The one now is based on technology, which really wasn't actively around then, but fracking was in experimental stages in the late 70s, early 80s. But it wasn't used consistently. It's used consistently and successfully now as a method of extraction. Okay. So you have a land that may have dispersed mineral rights. It may have mineral rights that you don't own. I recently looked at one, some property, which I can't name, of course, but some property, let's see, it was in Perkins County. Well, it had mineral rights owners that were living in Louisiana. And there was really no activity on the particular land recently. So you've got the mineral rights owners in Louisiana, you've got the surface rights owners in Perkins County, and what happens? Well, if the surface owner wants to recover the mineral rights, there's an opportunity to do that because of this dormant mineral statute. In South Dakota effectively says, if there has been inactivity, dormant activity, meaning no activity, by the owners of the mineral rights for the last 23 years, it is possible with a small p, that those rights, mineral rights, can be recovered back in favor of the surface owner. The important principle, well, one of the first important principles I want to talk to you about is only the surface owner, that is the title holder to the land, is the party capable of recovering back these mineral rights. Not their kids, not their prospective heirs, not their greedy grandchildren, but the real title holders. They're the ones that have the right to do this. If you're a leaseholder, even if you hold an existing lease that's an operational lease, that means an enforceable oil and gas lease, you don't have the right to recover minerals, only the surface owner. So the title holder or the rancher himself or herself as the party that can recover those rights. Nobody else has that right. Is that adequate? And that's not for me to answer. That's pretty typical. Most states have that. That's fundamentally what North Dakota says. The history of dormant mineral rights is as follows. Indiana, many years ago, wrote a dormant mineral rights recovery statute. And it allowed the surface owners in Indiana, and by the way, there's exploration and a lot of operations in Indiana too. It's much more prevalent in our country than you think, unless you start to work in the area. But Indiana wrote a statute and it said, well, we're going to allow the surface rights owners to recover mineral rights if there's been inactivity, an absence of activity for a certain number of years, simply by the owners filing a statement indicating that they have they've notified all prospective possible owners of the mineral rights to put a notification also in the newspaper, the local newspaper, notice by publication, and have made a so-called good faith effort to give notice to anybody that might really have an interest. And if there's silence, after a certain limited period of time, if there's silence, if there's nobody that stands up, raises their hand, I'm putting it metaphorically, that stands up, raises their hand and says, wait a minute, I own mineral rights in Indiana, even though I live over in Chicago, even though I'm a stockbroker, my grandpa gave me these. Well, that's